Hello everyone, this is Dr. Sanskriti Srivastava and I am presenting to you lecture on separation of powers. Doctrine of separation of powers. Separation of powers is a fundamental principle whereby powers and responsibilities are divided among the legislative branch, executive branch and judicial branch. The officials of each branch are selected by different procedures and serve different terms of office. Each branch may choose to block action of the other branches through the system of checks and balances. The framers of the Constitution designed this system to ensure that no one branch would accumulate too much power and that issues of public policy and welfare would be given comprehensive consideration before any action was even taken. The main objective of introducing their principles were to prevent the concentration of power and provide for check and balances. So basically, the principle of check and balances means that one organ can keep an eye or supervise the functioning of the other organs but cannot and must not interfere in the actions of the other. Moving forward to the next slide. The hypothesis behind the separation of powers is that when a single person or group has a large amount of power, they can become treacherous to citizens. The separation of power is a method of removing the abuse of power. Basically, the idea of separation of power here means that no one individual or no one single organization or political party must get so much of power or they must not acquire so much of power that they actually start abusing it or exploiting it. Moving forward to the next slide. It was Montesquieu, French jurist, who for the first time gave separation of powers a systematic and scientific formulation in his book The Spirit of the Laws, where he visualized three structural classification of powers into legislative, executive and judicial, and also emphasized that none of the three organs of the state legislature, executive and judiciary should interfere with the exercise of the functions of the other organ. So Montesquieu, a French jurist, was also of the same view that no organ of the government should interfere in the working or in the procedure or in the daily day-to-day legal formalities of any other department. Moving on to the next slide. The doctrine of separation of power, meaning by Montesquieu. First, a body or any person should not exercise all the three kinds of powers. Second, the same person should not form part of more than one of the three organs of the government. Next, one organ of the government should not interfere with any other organ of the government. Next, one organ of the government should not exercise the functions assigned to any other organ. And last, the legislature shall never exercise the judicial or the executive powers, while the executive shall never exercise the legislative or the judicial power, and the judicial branch shall never exercise the executive and the legislative. Moving on to the next slide. Judicial approach towards the doctrine of separation of power. In Ram Javaya versus Punjab, the Supreme Court held that the executive is derived from the legislature and is dependent on it for its legitimacy. This is a landmark judgment called Ramjavaya Kapoor versus State of Punjab. In this case, for the very first time, the Supreme Court held that executive derives their authority from the legislature, but it is dependent on its for its legitimacy. That means that executive has derived the authority from the legislature and it also derives its legitimacy from it. But still it does not mean that legislature or executive or the authorities or the people working in both the organs can interfere. No, it has just derived the authority from the other, but it cannot interfere. Moving forward to the next slide. In Re-Delhi Laws Act case, a 7-judge bench of the Supreme Court relied on the principle that one should not perform the functions which essentially belong to the other. For example, the magistrate sitting in the district courts cannot perform the functions of the Supreme Court or the High Court, or the collectors or the Supreme Court or the High Court judges cannot perform the functions of, say, cabinet ministers, or cabinet ministers or chief ministers cannot perform the functions, or the prime minister cannot perform the functions of a Supreme Court judge or a High Court judge. So this is what was held in the Delhi Laws Act case, that essential functions cannot be delegated and essential functions must not be performed by any other organ. Moving forward to the next slide. In Keshav Singh versus Speaker, Legislative Assembly, the Supreme Court relied on the doctrine of separation of power and pointed that Article 211 debars the state legislature from discussing the conduct of a High Court judge. The existence of a fearless and independent judiciary is the basic foundation of the constitutional structure in India. Basically, judiciary is also known as the watchdog for the rest of the two organs. Judiciary keeps a very strong, a very strict, rigid eagle's eye on their functions so that none of them abuses their power, because judiciary even has the power to take suo motu cognizance of the exploitation or for the violation of the fundamental rights of the citizens. So, fearless and independent judiciary is very important. Moving forward, in IC Golaknath versus State of Punjab, the Supreme Court emphasized the doctrine of separation of power. The then CJ Subbarao opined that the Constitution brings into existence different constitutional entities, namely the Union, the State, and the Union territories. It creates the three powerful instruments of power, namely the legislature, the executive, and the judiciary. It demarcates their jurisdictions minutely and expects them to exercise their respective powers without overstepping their limits. They should function within the spheres allotted to them. So, no one should violate their own jurisdiction. Moving forward to the next slide. In Indira Nehru Gandhi versus Raj Narayan, the respondent challenged the constitutional validity of Article 329A, which was added by the 39th Constitutional Amendment Act 1975, and argued that it is violating the primary feature of the Constitution. The court applied the landmark decision of Keshwanand Bharti and thus declared the impugned clause 4 of Article 329A to be unconstitutional. Justice Chandrachud said that as the pure judicial function is being transferred into the legislature's hands, it therefore amounts to the violation of the principle of separation of power. No one can violate the primary features of the Constitution, and this judgment was hugely criticized by Justice Chandrachud. Moving forward, in Asif Hamid versus the state of Jammu and Kashmir, the rigidity of the doctrine of separation of powers in India was absent. However, the limitations of every organ are predefined as legislature, executive, and judiciary have to function within their spheres as mentioned under the Constitution. Although the judicial review helps to check the unconstitutional functions of the legislature and executive, the judiciary must have self-imposed disciplinary provisions while exercising the powers of judicial review. The power of judicial review actually is very important. It is given in the Article 13 of the Constitution of India, and it provides that judiciary can declare any law, any order null and void if it violates any of the articles providing fundamental rights to the citizens. Moving forward. So this was the last slide. Thank you.